Hey there, curious minds. Welcome to the Deep Dive, your shortcut to being genuinely well-informed. Today, we're plunging into, well, what might seem like a pretty technical corner of the legal world, but stick with us because it actually reveals so much about how courts work, how rules interact, and why a tiny procedural slip-up can sometimes have really big consequences. We've got some legal documents here, specifically excerpts from a recent Court of Appeal judgment out of Lagos, Nigeria. Our mission today. To unpack this specific case, it really shows this intricate dance between different sets of legal rules and, how a court decides which one wins out. And it's fascinating because it's all happening within a divorce case, something so personal, yet the mechanics of procedure take center stage.
It really is a perfect example of legal interpretation, isn't it? The court isn't just reading rules in isolation. They have to figure out how they fit together, or sometimes how they don't clash when maybe you'd expect them to. And what's interesting here is how the court draws the line. When is something like matrimonial law truly unique, sui generis, and when can it borrow from the general rule book?
Okay, let's dive into the specifics then. This case started not really about the divorce itself, but about how it was being handled procedurally. A missed deadline, basically. We have Mrs. Olubunmi Olujumoke Ogundare and Mr. Adiyinka Adeyemi, let's just call them the appellants, appealing against Mr. Tubosun Christopher Ogundare, the respondent.
That's right. So the whole thing kicked off in the High Court back on June 20th, 2019. The appellants, they needed more time. They filed an application for an extension to get their amended documents in their answer, cross-petition reply. Basically, they were late submitting key paperwork.
And the High Court didn't just say, okay, no problem.
Yeah.
There were strings attached. Right.
Definitely strings attached. The court said, look, we'll grant the extension, but maybe they wouldn't deem those late documents properly filed until the appellants paid default fees, and $1,000 per day for every day they were late. And that wasn't all. On top of the daily fees, they were each ordered to pay $100,000 in costs because their delay meant the scheduled court proceedings for that day had to be scrapped.
Wow. So just being late with paperwork suddenly means daily fines piling up, plus a hefty one-off cost. You can see why they might feel, well, a bit aggrieved. This is where they decided to challenge it, taking it up to the Court of Appeal in Lagos. And we have the judgment from August 5, 2024. So the appellants were, as the court document says, dissatisfied. Their appeal boiled down to one core idea, didn't it? That the High Court judge simply applied the wrong set of rules to their divorce case.
Exactly. Their main argument hung on this term, sui generis.
Okay, let's make sure we're clear on sui generis. Sounds quite formal, but what does it mean in this legal fight?
It literally translates to of its own kind. Unique. Special. So, in law, if something is sui generis, it means it operates under its own distinct, specific rules, separate from the general laws or procedures. The appellants were saying divorce proceedings are like that. They argued these cases are governed only by the matrimonial causes rules from 1983, and because of that, the General High Court Civil Procedure Rules of Lagos state the 2019 ones that cover most civil cases they just shouldn't apply here, meaning no legal basis for those daily default fees or the N100,000 costs for the adjournment.
Right, so their logic was, there's a special divorce rulebook. That rulebook doesn't mention these specific fees or costs, therefore you can't just pull them in from the general rulebook. It's an argument for complete separation of the rules.
Pretty much. They even pointed out that, statutorily, only the Chief Justice of Nigeria can make rules for matrimonial causes. Their implication was, unless the Chief Justice amended those 1983 rules to include these penalties, the Lagos High Court judge was overstepping by using the Lagos state rules. So they framed their appeal around two key issues for the court to decide. One, can you use the Lagos High Court rules for default fees in a divorce case, given the specific matrimonial causes rules exist? And two, was that N100,000 cost order punitive, arbitrary, basically unfair?
Okay, a clear stance from the appellants based on this sui generis idea, but the respondent, Mr. Ogundare, he obviously disagreed. How did his side push back?
The respondent's argument was, well, quite neat, actually. They framed it as a single issue. Was the High Court right to make the orders it made? Simple as that. Their core point was that the main law here, the Matrimonial Causes Act, it doesn't actually say state high court rules are completely excluded. They argued those general rules only get kicked out if they're inconsistent with the specific Matrimonial Causes Act or its rules.
Ah, inconsistency. That's the key difference, isn't it? Not automatic exclusion, but exclusion only if there's a direct conflict. That's a crucial distinction.
It really is. It changes the whole dynamic. The respondent also highlighted something practical. The High Court did grant the extension the appellants asked for. The fees were just a condition attached to that grant. So they argued, objecting to the fees was misplaced since the appellants got the extra time they needed. And on the costs. They fell back on the established principle that awarding costs is generally up to the court's discretion. Appellate courts usually won't mess with that unless the judge clearly acted unreasonably or arbitrarily. And they cited case law to back that up.
Okay, so this sets up the central conflict the Court of Appeal had to resolve. You've got the appellant saying diverse rules are totally separate, and the respondent saying no, general rules apply unless they clash. Way. How did the Court of Appeal, specifically Justice Mohammed Mustafa, untangle this? Where did they look for the answer?
They went straight to the source, the Matrimonial Causes Act itself, specifically Section 112. This section deals directly with the power to make rules for these kinds of cases, and it turned out to be, well, pretty decisive.
Okay, Section 112. What did it say that was so critical, especially against that sui generis argument?
Well, subsection 1 confirms the Chief Justice of Nigeria can make rules for matrimonial proceedings, including costs. No surprise there. But then subsection 2 adds a layer. It says the power of a state high court to make its own general rules for practice and procedure also extends to these matrimonial matters.
So it's not just the Chief Justice. State high courts have a role, too.
Exactly. But then subsection 3 provides the crucial qualifier. It states that those state high court rules are excluded only to the extent of any inconsistency with the matrimonial causes rules.
There it is again. Inconsistency. So the Act itself seems to build a bridge, not a wall, between the two sets of rules. It directly refutes the blanket sui generis means total separation idea.
Precisely. It completely undercut the appellant's main pillar. The Act itself allows for the general rules to fill gaps as long as they don't contradict the specific ones.
Okay, that deals with the general principle. But did the specific matrimonial causes rules, the supposed special rule book, did it actually say anything about conditions or costs for extensions? Or was it silent, like the appellants claimed?
Well, this was another blow to the appellant's case. The Court of Appeal pointed directly to Order 23, Rule 33 of the Matrimonial Causes Rules themselves, and that rule explicitly says an extension of time can be granted upon such conditions as the court thinks fit.
Conditions the court thinks fit, so it allows for conditions.
Yes. And then Subrule 4 goes even further. It says, unless the court orders otherwise, the costs of applying for an extension shall be borne by the applicant.
Wow. So the specific divorce rules do actually mention conditions and costs related to extensions. The appellants claim that there was no provision. Seems to fall flat.
Absolutely. The court found this was perfectly consistent with the High Court imposing conditions, like the default fees. And when they looked at the Lagos High Court Rule, Order 48, Rule 4, which specifies that N1,000 per day default fee, they found no conflict. The specific rules allow conditions, and the general rules provide a specific mechanism for calculating a fee for lateness. They work together.
So the Court of Appeal concluded the default fee order was fine. It fit within Section 112 of the Act and didn't clash with the matrimonial causes rules. That really unravels the first part of the appeal.
It does. And then they turn to the second issue, the N100,000 cost order for aborting the trial day. Here they went back to basics. The principle of costs follow the event. Costs aren't meant to be a punishment or, a bonus prize. They're generally awarded to cover inconvenience or expenses caused by one party's actions or the proceedings themselves.
Right, so it's more about compensating for the disruption caused by the delay, not about penalizing the appellants financially beyond that.
Exactly. It's not about curing financial losses in the wider sense. The key point, again, is judicial discretion. Awarding costs is up to the judge, but that discretion has to be exercised judicially and judiciously, meaning based on reason and legal principles. An appeal court won't interfere just because it might have awarded a different amount. You need to show the judge acted wrongly, arbitrarily, or ignored irrelevant factors. And in this case, the Court of Appeal found no evidence that the High Court judge had exercised that discretion improperly. The costs order stood as well.
So after digging through the Act, specific rules, the general rules, and the principles of judicial discretion, what was the final verdict for the appellants?
Well, having found no merit in either ground of appeal, the Court of Appeal resolved the whole issue in favor of the respondent, Mr. Ogundare. The appeal failed. The original ruling of the High Court from June 20, 2019, including the default fees and the N100,000 costs, was affirmed. It all stood.
And I remember reading they didn't stop there. There was an extra cost associated with the appeal itself.
That's right. The Court of Appeal awarded a further cost of N500,000 against the appellants, payable to the respondent. It serves as a reminder, really, that launching an appeal that the higher court finds lacks merit can end up being quite costly in itself.
Okay, so we've really unpacked this specific case from Lagos. But stepping back, what are the broader takeaways here? Why should someone listening, maybe not involved in Nigerian divorce law, care about this?
Well, I think it's a fantastic illustration of how systems of rules work or are supposed to work everywhere. This idea that even specialized areas, things we think of as sui generis, often still exist within a larger framework of general principles or rules. You can't always just isolate one set of rules. You have to see how they interact with the bigger picture. Ignoring that interaction can lead you down the wrong path, legally or otherwise.
Yeah, and it definitely hammers home the importance of procedure, doesn't it?
Yeah.
Deadlines matter. Following the rules matters. What started as perhaps a simple delay in filing paperwork spiraled into significant daily fees, substantial costs, and then even more costs for an unsuccessful appeal. Procedure isn't just trivial bureaucracy.
Absolutely not. It has real teeth. And the other big takeaway is about discretion. Courts, especially higher courts, tend to respect the judgment calls made by lower courts on procedural matters like costs or granting extensions, unless there's a really clear error. Challenging that discretion is tough. You need to show the judge didn't just make a decision you disagree with, but that they made it wrongly, based on incorrect principles or arbitrarily. That's a high bar.
So this whole deep dive really illuminates that constant tension in law and maybe in many complex systems. How do you balance specific rules for specific situations against the broader general rules? How do you ensure fairness and consistency while still allowing for judicial discretion? It's a complex balancing act.
It really is.
So maybe the next time you encounter a situation with special rules, remember this Ogundare case. It's a good reminder that special doesn't always mean entirely separate. You often need to understand the general context too.
Yeah, and leaves you thinking, doesn't it? What's the ultimate aim when applying rules in court? Is it absolute perfect adherence to every single written word, even if it slows things down? Or is it about achieving a just and efficient outcome, which might mean using discretion to impose conditions, like fees for delays, to keep the system moving fairly for everyone involved?
That's a really interesting question to ponder. Okay, that's all the time we have for this deep dive. We hope you feel a bit more informed about the fascinating and sometimes complex world where different legal rules collide. Until next time, keep digging, keep questioning, and keep learning.